everyone. Thank you for coming to the symposium on mainstreaming. Let me get my mainstreaming of extremism in U.S. state and other public institutions. We had a great session yesterday where we had 2 panels and responders in between each panels, and we have another great day scheduled for right now. So what we're going to do is our first panel is called Armed and Influential, the Rise and Role of Militias. And as each person prepares to talk, I would like them to introduce themselves so that I don't have to waste people's time going through introductions of everyone. I think it's better to have a name with a face anyway. And then after that panel is done, after the speakers have all spoken, we'll have questions and answers from the participants, or as well as the audience. And audience members, you should see a Q&A at the bottom of your screens. Feel free to type messages in there at any point when you have questions. And if they're logistical or something, we can address them offline. If not, I'll read them during the Q&A sessions. And after the questions and answers have ended, then I'm going to invite responders to come and just have a conversation about what has been said. And so responders are people who are either out in the field and have work associated with the topics that we're covering, and pardon me, I just got a message from our first speaker who is trying to find the link. Danny, could you send Dakota the link to
Yes,
get into the session? Thank you.
Yep, I'll do that right now.
Okay. So the responders will have a conversation about this, and at any point, if they have any questions directly to any of the panelists, the panelists will turn on their cameras to talk about it. So anyway, it should be a great day. And our first speaker is Dakota Rudesill. And Dakota, hi. I was just going to ask you to turn on your camera. And what I had mentioned is that we're going to have everybody introduce themselves before they start speaking. So those of you know, when you turn on your camera, you'll be visible, and when you turn off your camera, you won't be visible. And so I'll be asking you to turn your cameras on. So thank you, Dakota.
Again, this project is called Militias End, and it is it's a bit of a play on words. So the first word is militia, as in what the Constitution references as the militia. And I'm going to argue about, my article argues about one way in which I think that one understanding of militia anyway should end. The play on words is that if you say it, militias end, it also sounds like malicious end, as in bad intent end. And my basic argument here is that I think that what we really need to do is to regard the attack on the Capitol of January 6th, which involved very significant militia activity, really probably the most prominent that we've had in our country at least since the Klan's militia, violence of of many decades, or Oklahoma City, perhaps. But anyway, it's, just a red letter date in American history in a variety of ways. Anyway, I think that January 6th needs to be regarded as a malicious end, if you will, of the idea that that violence can be privatized by self-organized militias, and that they have some sort of legitimate civic role. I think we need to bring that to an end, and Congress has the constitutional authority to do that. Just to start off, I want just to say a word about words, because I think that they're relevant to this project and important, and I think relevant to, obviously, the really, really difficult times that we live in. So I'll just say a brief word about 3 words and how they relate to the project. So these are words that are in the caption and conceptualization of our conference. So one is extremism, and I'll say what I say when in all of my courses that I teach, and all of them bear in some respect on current events, and people are going to bring in all sorts of prior opinions and preferences and whatnot. So what I say there is what I'll say here, which is that there's no partisan agenda, but we do have a values agenda. One of those values is nonviolence in politics. I admit, as somebody who believes in the rule of law, that I believe that violence, and especially violence, not private violence in politics in our republic, is completely illegitimate. I can imagine circumstances in which armed resistance to an authoritarian state, something like that, might be arguably legitimate in some circumstances. We are eons from that, despite what unfortunately a number of people think. So one of my values is nonviolence in politics. That has been the norm that we've had in this country, and it's been a really, really powerful and valuable norm for quite a while. Also, a government monopoly on violence that has some sort of civic valence to it. Obviously imperfect, but compared to a lot of countries, a very good record. In that context, therefore, I would say that violence in politics, therefore, is extremism. And if you are part of a militia, if you think that militias have some sort of militias and militia violence have some sort of legitimate place in our in the American Republic in the 21st century, I would say you have extremist views. So that's how I'd conceptualize that. Second is right wing. So I think it's just a factual matter where we are at this point based on the data, right? That there's just a much larger militia presence and activity on the right than there is the left. It was not always this way. The Klan was typically associated with the Democratic Party for about 100 years, and was a lethal and massively impactful militia. But this is where we are, right? There's certainly militias on the left. There's Antifa. There are, animal rights or eco violent groups, but their numbers are small and their impacts are relatively limited compared to the ones that that we saw attack the Capitol on January 6th. So that's not a statement about conservatism, libertarianism, everybody who votes red by any means. It's simply an analytical statement about where the extremist militia violence is overwhelmingly right now. And finally, the last word that I'll say is just states. So there's been certainly evidence in Ohio of private militia activity. Indeed, a fair number of people who were involved in January 6th were from Ohio, and certainly activity here. There's not evidence that I've seen that anybody involved in government in Ohio is endorsing militia violence, promoting it, wanting to use it for public purposes, which is part of what I'm going to be talking about. So I just wanted to underscore that. So I start my article with a snapshot of two militia moments, as I call them. So here's the first. So after civic violence, a self-organized violent militia loyal to the chief executive surrounded a meeting of the legislature until it voted the leader extraordinary powers. Law enforcement and professional military did not challenge the militia because it had been put on official duty. That's one militia moment. Here's a second militia moment. A militia loyal to the chief executive violently attacked the legislature in an effort to intimidate the legislature into granting the chief executive the unconstitutional power of an extended term, but its appeals to the chief executive for official status went unanswered, and the militia was repulsed by law enforcement and organized militia. And later, many of its leaders, members, and fellow militants were prosecuted and sentenced. So the first of these two militia moments was 1933 in Germany. The militia in question was the SA, the stormtroopers, the brown shirts who surrounded the Reichstag after the Reichstag fire, literally surrounded the legislators until they voted the leader extraordinary powers. That essentially extinguished Republican government in Nazi Germany. The second militia moment was obviously January 6th. A key difference between these two moments is that in Germany in 1933, this militia that was loyal to the leader had been given official legal status. In the second case, in January 6th, they had not. Stuart Rhodes, leader of the Oath Keepers, a number of other militia leaders, were appealing to President Trump to invoke the Insurrection Act and put them on official duty as militia. So what they could be doing would have official government cover. And Trump did not do that. And that's an enormously important and consequential distinction. It was enormously important on that day, and it is going forward. People can reasonably wonder how on earth in the United States, if you're not somebody who's a national security law junkie, how would they have any hope of being put on official duty, right? Just a bunch of people with, they buy, some armor and weapons off Amazon and whatnot. How could they be on official government duty? Well, I'll talk about that in a second. The bottom line is that under our legal system, as it stands right now, just like it did on January 6th, is there's really, really significant danger that basically self-organized militias can be put on public duty to do political violence for what I term a wicked chief executive. If you're a chief executive and you're contemplating putting self-organized militias on official duty to do violence for you, I would say you are a wicked chief executive. There are my values again. And there's a danger at the federal level, and that there's a potential danger in a number of states as well. And I recommend some legal changes to that. Just briefly, I'll start with the federal legal structure here. So the U.S. Constitution in Article 1, Section 8, Clauses 15 and 16 gives the Congress almost complete control over what the Constitution calls the militia. The militia at the founding was understood to be military-age men. And this was a change from the Articles of Confederation, when the militia was just a state-level entity. The Constitution of 1789 gave the federal government, especially the Congress, complete control over their discipline, their organization, uniforms, weapons, everything, and the ability to call them to federal duty, to write statutes that gives the president the authority to call them to federal duty, to do federal national stuff, and also to take them away from governors, right? Take them away from governors and state legislatures. So that's the Constitution. In the founding era, the Congress wrote a couple statutes that are enormously important and still with us in amended form. So one is called the Calling Forth Act. That was a very, very early act that then had Congress executing its constitutional authority to give the president authority to call forth the militia, to repel invasions, respond to what the Constitution calls domestic violence, things of that nature. The second statute that is of importance, built on the Calling Forth Act, as the Insurrection Act. So the Insurrection Act also allowed the president, and the Insurrection Act got amended during the Civil War and a number of other points, but it also provides the president the authority to call forth militia to put down rebellions and insurrections against states and against federal authority. It is an extremely capaciously written statute, very, very capacious. It's been invoked a number of points in American history, 1950s and 1960s, by both Republican and Democratic presidents to deal with insurrection, or not insurrection, segregationist, but also arguably insurrectionist Southern governors who were using their National Guard forces to resist integration, most recently in 1992 during the Los Angeles riots. So jumping back in history for just a second, a really, really big change occurred in about 100 years ago with a law called the Dick Act, named for an Ohio congressman, and some amendments to that. And basically what the Dick Act did is it created two classes of federal militia. One class is the National Guard. And the National Guard, as crafted by Congress, was a professionalized reserve force to be on default state duty, but to be fully integratable with the standing federal forces, right? It's a professionalized reserve force, but at the state level, unlike the the formal like Army Reserve, Navy Reserve, which are only federal. So the National Guard is a state level reserve force, fully integratable with the federal forces. That's the organized militia under statute. The unorganized militia under statute, under the Dick Act, is basically all military-age men who are not in the National Guard, right? And it's just this kind of residual thing. That's kind of like the old founding era understanding of the militia. The unorganized militia has never been called forth. And arguably, it could only be called forth under the Insurrection Act. And that is because the Insurrection Act has not been modernized. It still carries the founding era term of militia, right? That the president to resist, to put down, resist, manage rebellion against government authority at the state level or the federal level can call forth the standing duty armed forces, the National Guard, or militia. The term is still in the Insurrection Act. In contrast, the Calling Forth Act, which has been amended starting in about 100 years ago to be about the National Guard, right? So we have the law got updated with regard to calling forth what the Constitution addressed as militia to reference the National Guard, right? And so when we have disasters, when we have civic unrest, right? It's the National Guard that gets called out, first by state governors, if necessary by the federal government, right? But the Insurrection Act still carries this term of militia. So what this does is it created an opportunity for militia leaders in this country to argue that the president could call forth the unorganized militia under the Dick Act, which is just, again, military-age men to be on official duty. And what Stuart Rhodes and the Oath Keepers and the Proud Boys and what others of them wanted to do was they wanted the 45th president to put them on official duty and then have them do violence, occupy the Capitol, take control of the election system, all manner of things like that. So when I look at this, I say, well, January 6th in a way could have been even worse, right? What if the president had put them on official duty? What a complete nightmare that would have been, and that risk and danger persists. Very, very briefly, and I won't go on too much longer, but so at the state level, so the states vary about how they concern the militia, but all of them have law that address the militia. And generally what they have a combination of constitutional law and statutes written by the legislature, which govern the militia at the state level in the context, right, of the federal constitutions granting to the federal government, especially to the Congress, the power to completely override anything the states do on the militia, and even remove it, right, and put it on federal duty. And so states often have kind of the same kind of organized, unorganized militia distinction that the federal government does. There are some variations in it, but kind of an analogous structure. And many of the states as well have really, really clear signals in law, either in their constitution or in statute, that say that the militia, again, this kind of founding era understanding the militia is subject to civil authority. Some of them go even farther and explicitly prohibit private armed groups that are organized for political purposes, right? Prohibit them. The U.S. Supreme Court, about a little over 100 years ago, said that private armed groups that are organized for political purposes can be prohibited, and that is not a Second Amendment violation. And in fact, that case was cited by Justice Scalia in the Supreme Court's Heller decision in 2008, right? So you can have the Second Amendment, right, and even expansive Second Amendment, as understood by Justice Scalia in the Heller decision, which found an individual right to bear arms for the first time, as opposed to a right in connection with militia, right? But even in the context of expansive Second Amendment rights, right, the Supreme Court has emphasized that private groups organized for political purposes that are armed, right, those can be prohibited. So essentially what I'm recommending, and I'll just wrap up here and look forward to discussion, is both kind of a more minimal change to the law and some other more expansive changes to the law. So at the federal level, that word militia in the Insurrection Act needs to come out, and it needs to be replaced with the National Guard to foreclose the possibility that, again, a wicked chief executive could basically just put like random armed dudes on official duty and have them do political violence for the president, right? That needs to go away. And once the Insurrection Act gets amended in that way, I've been scouring the statute books for quite a while now, and there's no other authority I found in federal law for the president to put militia on duty as opposed to the National Guard. And that's a really important distinction, because the National Guard, as a professionalized military force, has a modern professionalized ethos, right? They're subordinate to civil authority. They stay out of politics. They have judge advocate generals. They have lawyers, right, who are trained in the law of armed conflict and civil military relations, right? And there would be, I just could not imagine. Well, anyway, that's kind of another topic. How much would the National Guard do if mobilized for some purposes that I think that a lot of folks would consider wicked? But certainly that, the professionalized National Guard is a very different creature than, just people who live in your neighborhood who, have guns and kind of want to be, these kind of rugged heroes. So I think that's important. I think National Guard needs to be inserted in the place of militia. And there's some other changes that I think that could be made as well. I think there could be an explicit national ban on groups that are armed on a nationwide basis for political purposes, right? Still individual, ability to bear arms. You still have your freedom of association for non-violent purposes, right of petition, right of demonstration, all that stuff, right? You just can't create a private military entity, right? I think the constitutional law is very clear that that can be done. I think similar things should happen at the states, where there are a number of states that are less clear than other states about prohibiting armed groups. I think that would be helpful as well, and some clearer rules about mobilization of these entities. I mean, where, for example, in states which have this distinction again between the organized militia and the unorganized militia, I think Ohio actually is pretty instructive in saying that, under no circumstances can the unorganized militia be mobilized until the organized militia, right, has been, meaning the National Guard forces, right, and other organized state forces. So basically the idea is that kind of like you have to have, kind of the more professionalized state forces that are considered militia, right? They need to be tapped out basically before there could be any sort of thought, right, that that a state could, just call on just kind of random people with guns, right, to start doing stuff for the state. And I think that's enormously important. Together with a ban on armed groups for political purposes, to make, to also foreclose the possibility that a wicked state executive could try to, put just, armed mobs, right, on public duty to do political violence for them. I never thought at the start of my career 30 years ago, working in law and national security and legislation, that I would ever be worried about this or concerned about this. But here we are, and unfortunately it's a real issue. So appreciate your attention to this. Look forward to your questions and to discussion.